Hello, everyone, and thank you for joining us today. I am Stuart Frank, Director of the Agricultural Marketing Service, Packers and Stockyards Division. Welcome to our briefing on the final rule, inclusive competition and market integrity under the Packers and Stockyards Act. This webinar session is being recorded. A link to the webinar recording will be made available following the broadcast to all registrants. To reduce background noise, your microphone has been muted. Your video feed is also blocked. We do this to protect the privacy of all our attendees. You have the option to activate closed captioning to appear before the bottom of your viewing screen. Click on the CC option located on the toolbar along the bottom of your monitor. We will not be using the chat room today, but the question and answer box will be open throughout the presentation. Please take a moment to locate the Q&A option located on the toolbar at the bottom of your monitor. Please enter any questions or comments using the Q&A box. You may choose to enter them anonymously by checking the anonymous box before clicking send. At the end of today's webinar, we will address questions that were submitted prior to the presentation. We will supplement the set of frequently asked questions, FAQs, from those previously submitted and from today's webinar. The FAQs are posted on the AMS website. With that, we will begin our presentation. The Inclusive Competition and Market Integrity Final Rule was published in the Federal Register March 6, 2024, and will become effective May 6, 2024. Joining me today is S. Brett Offit, Packers and Stockyards Division Chief Legal Officer, and Julie Shiflett, Economist, Packers and Stockyards Division Competition Branch. During the presentation, we will provide an overview of the rule, the specifics of the rule, and at the end of today's webinar, we will address some of the questions that were submitted prior to the presentation. Now, I'm going to turn it over to Brett Offit to begin our discussion of the Inclusive Competition and Market Integrity Rule. Brett?
Thank you, Stuart. As its title indicates, the goal of this rule is to promote inclusive competition and market integrity in the livestock and poultry markets. The rule makes clear that undue prejudices and unjust discrimination against individuals on a prohibited basis will not be tolerated. The rule identifies retaliatory practices that are unlawful under the Packers and Stockyards Act, and it specifies deceptive practices related to all stages of contracting that violate the act as well. With this new rule, USDA stands with producers and growers around some very basic concepts. The first is that farmers and ranchers should not suffer discrimination on the basis of race, sex, or other protected basis. Second, farmers and ranchers shouldn't be retaliated against for exercising basic rights. And third, farmers and ranchers should not be deceived or misled in any aspect of contracting. What does this mean? What are some real life examples? Poultry growers have reported receiving underperforming flocks, for example. They may be underperforming because of sick chicks, for example. Under this rule, intentionally delivering underperforming flocks to a grower is considered discrimination or retaliation if it is based on a prohibited basis or in response to a grower engaging in a protected activity. We've also had livestock producers report concerns and fear of retaliation that may stop them from contacting buyers or government officials to question market practices. About 2 years ago, the House Agriculture Committee, as another example, held hearings on livestock competition issues. One of their scheduled panelists, a rancher, chose not to participate after acts of intimidation and threats. The Senate Agriculture Committee was holding hearings around the same time and also had difficulty getting cattle producers to come forward out of fear of retaliation. These practices are obstacles to competitive markets and undermine market integrity and will not be permitted under this rule. Let's talk a little bit about the rule specifics. The rule has 4 objectives. The first objective is that it prohibits undue or unreasonable prejudices or disadvantages by regulated entities against covered producers on the basis of race, color, religion, national origin, sex, including sexual orientation and gender identity, marital status, age, or because of the covered producer's status as a cooperative. Just who is a regulated entity? We'll pause here for a moment. Regulated entities come in 3 different types. They are packers, swine contractors, and live poultry dealers. And for clarity, a live poultry dealer is a company or a person that buys or obtains live poultry from a grower in either a cash sale or under a poultry growing arrangement. Well, then who are covered producers? Covered producers are also in 3 types. One is a livestock producer. A livestock producer, as you can guess, is someone who raises and cares for livestock, but it does not include an employee of the livestock's owner. The second type is a swine production contract grower. These are people who raise swine under contract for someone else. And the third type of covered producer is a poultry grower. Well, what type of conduct is prohibited? There are several specified in the rule. And if you take a look at the rule, you'll see that those include offering contract terms less favorable than those ordinarily offered to similarly situated producers, refusing to deal with a covered producer on terms ordinarily offered to similarly situated producers, performing under or enforcing a contract differently than with similarly situated producers, requiring a contract modification or renewal on terms less favorable than with similarly situated producers, or terminating or not renewing a contract. Now, there are certain things that are not prohibited. For example, conduct that's undertaken to fulfill a religious commitment relating to livestock, meat, or poultry, and conduct by a federally recognized tribe in performing its tribal governmental functions. The second objective is that the rule identifies retaliatory practices that interfere with lawful conduct as unjust discrimination prohibited under the Packers and Stockyards Act. Lawful and protected conduct in this respect includes communicating with a government entity. That could be federal government or state or local government. Refusing to communicate at the regulated entity's request with a government official if that communication is not required by law. Asserting the right to form or join a producer or grower association or organization. Communicating or cooperating with others to improve production or marketing of livestock or poultry. Also, lawful and protected conduct is supporting or participating as a witness in a proceeding under the Packers and Stockyards Act, or asserting any rights granted under the Act. So what conduct would be considered retaliation? Some of the same as we discussed earlier. Terminating or not renewing a contract could be retaliation. Performing under or enforcing a contract differently than with similarly situated producers. Requiring contract modification or renewal on terms less favorable than those of similarly situated producers. Interfering in farm real estate transactions or contracts with third parties, or other actions that a reasonable producer would find materially adverse. The third objective of this rule is that regulated entities may not engage in deceptive practices at any of the various stages of contracting. They cannot deceive or mislead during contract formation. That includes communications leading up to and negotiations before and up to the execution of contract. They cannot deceive or mislead during contract performance. That's during the term or the life of the contract. They cannot deceive or mislead regarding the reasons for a contract termination. And they cannot deceive or mislead regarding the reasons for not entering a contract. With regard to deception, whether contract language was clear and written in a language the producer understands will be part of any evaluation to determine whether a statement, including an omission, was false or misleading. And that determination will be dependent on the particular facts and circumstances of the contract. The fourth and last objective I'll discuss today is record keeping. This rule requires that certain records be kept to support the monitoring, evaluation, and enforcement of the rule. Records must be retained for a minimum of 5 years from the date they're created. And the relevant records include, as you see on the slide, policies and procedures, staff training materials, materials informing covered producers regarding reporting mechanisms and protections, compliance testing, board of directors oversight materials, and the number and nature of complaints received relevant to this rule. I'll now turn this over to Julie Shiflett for a summary of the rule and to address some of the questions about the rule.
Thank you, Brett. In summary, what a violation of Section 201-304A discrimination could look like. If prohibited actions such as offering less favorable contract terms, refusing to deal with a covered producer, and other actions described in the rule are taken by a regulated entity on the basis of a covered producer's race, color, religion, and other protected bases in the rule, then such conduct is discriminatory and can result in a PNS Act violation where determination will depend upon available evidence. In summary, what a violation of Section 201-304B retaliation could look like. Prohibited actions by regulated entities are retaliatory, such as terminating or not renewing a contract, or refusing to deal with a covered producer on equal terms, and other actions described in the rule, if they are taken in response to a covered producer engaging in a protected activity, including communicating with a government entity, asserting the right to form or join a producer or grower association or organization or cooperative, or 3, asserting contract rights and other activities described in the rule can result in a PNS Act violation where determination will depend upon available evidence. Answers to commonly asked questions. When has a violation occurred? Question 1. If a producer or grower has been harmed by an adverse action, is the fact that they belong to a protected class sufficient to violate the regulation? No. To violate the regulation, a regulated entity must take an adverse action on the basis of the membership in the protected class. Question 2. Does the producer or grower membership in a protected class matter in cases of retaliation? No. A producer or grower does not need to be in a protected class to receive protection from retaliation. A regulated entity violates the regulation if they retaliate against a producer or grower that engaged in protected activities. Question 3. Who is protected from deception under the rule? Producers and growers are specifically protected from deception, regardless of their activities or membership in a protected class. Question 4. Does some additional harm to competition need to be shown above and beyond the requirements of the final rule? No. When determining whether to bring a case based on an alleged violation under this rulemaking, AMS will only consider the standards in the regulations. I will now turn the presentation back over to Stuart Frank. Thank you.
Thank you, Julie. So you may submit any questions you have about the Inclusive Competition and Market Integrity Rule to the AMS-askPSD@usda.gov email. This email can also be found on the AMS Fair Trade Practices Packers and Stockyards Division Contact PNS webpage. We will supplement the FAQs with any new questions received today or through the Ask PSD email. You can scan the QR code on the screen now to go to the AMS Packers and Stockyards webpage to view the information and materials for the Inclusive Competition and Market Integrity Rule, including the text of the final and proposed rule, webinar information, and a final rule fact sheet. I want to thank you again for joining us today for our webinar on the Inclusive Competition and Market Integrity Rule. A recording of today's webinar will be available on the AMS Packers and Stockyards webpage. This concludes today's webinar. Thank you.